Hi, my name is Carl Pearson, and I want to do this video which will act as a warning about arbitration. And I call this video, Arbitration is a Fraud. What I'm talking about are the non-consumer type arbitrations. And you have to fight arbitration, I think, as if arbitration is one of your opponents, and when you are stuck with an arbitration agreement. Usually this happens when you want to buy or use something offered by a major corporation, often a corporation dealing with the public, which requires you to agree to arbitrate instead of exercising your right to start a lawsuit in court and get a jury trial. You should read the agreements you so readily agree to when visiting and using websites, for example. My background, I'm a Harvard Law School graduate. I've been practicing law for more than 40 years in New York City, mainly in antitrust and intellectual property, commercial, and civil rights litigation, including some arbitrations, I should say. Also, I was a pioneer in advocating arbitration by creating the concept for what I called the National Private Court, an arbitration system which was to be done by the rules of law, including an appeal, a pretty novel concept at the time. Now, arbitration agreements have problems, and I want to discuss them with you. Many large corporations have agreements or forms that require customer disputes to be submitted to arbitration. The reason for this is that historically, the designated arbitration organizations and their arbitrators overwhelmingly tend to favor the large corporation, obviously in order to make sure that they continue to be designated as the arbitrating organization. Arbitration itself is a denial of your right to a jury trial, in which right is included in the U.S. Constitution as a check and balance on the awesome power of a judge. When you are required to arbitrate a dispute, you lose this important constitutional right and may lose about 80% of your chances of winning in comparison to a court and jury trial. Consumer disputes in arbitration generally have a large corporation paying most or all of the arbitration fees, which of course is slight consolation for the opportunity of having about 1/5 of a chance of winning in comparison to being in court and trying your matter before a judge or jury. The real problem, however, is with non-consumer arbitrations. These agreements typically are between a large corporation and a small business or an individual. The evil is that the agreement requires the two participants to share the arbitration fees equally, that is 50-50. What you don't realize is that these fees are often an hourly fee paid to the arbitrators, and there could be one or three, of about $300 to $750 per hour, with the arbitrators being able to charge a large number of hours in a single arbitration, such as 50 or 100 or 200 hours, or a fee of $15,000, $75,000, or even $150,000 or more. This means that the small business would be required to not only pay its own lawyer, but pay $7,500 to $37,500, perhaps $75,000 or even more to the arbitrators, one or three, in cases involving higher alleged damages. For most small businesses, this means that the option to arbitrate is not an option at all, and they wind up losing the right to sue. Not only do you lose the right to a jury trial, you lose your right to obtain any relief at all when you sign or are forced into having a non-consumer arbitration. What do you do if you are stuck with a non-consumer arbitration agreement? The Federal Arbitration Act requires that a dispute be submitted to arbitration even if you were induced to sign the overall agreement by reason of fraudulent inducements or representations. Chapter 9 of the U.S. Code, Section 2, entitled Validity, Irrevocability, and Enforcement of Agreements to Arbitrate, a federal statute, provides, in relevant part, a written provision in any contract to settle by arbitration a controversy thereafter arising out of such contract shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. The Supreme Court, U.S., has held that such language requires the arbitration provision itself to have been procured by fraud and not the overall agreement. If the overall agreement was procured by fraud, the arbitration provision remains valid according to the U.S. Supreme Court in Prima Paint versus Flood and Conklin, 388 U.S. 395, a 1967 decision of the Supreme Court, in which it held that in passing upon an application for a stay of arbitration under Section 3 of the Act, a federal court may not consider a claim of fraud in the inducement of the contract generally, but, quote, may consider only the issues relating to the making and performance of the agreement to arbitrate, unquote. Also held that since the claim of fraud here relates to the inducement of the consulting agreement generally, rather than in the arbitration clause, and there is no evidence that the parties intended to withhold this issue from arbitration, there is no basis for granting a stay. This statute and the Supreme Court's decision obviously were something that the major corporations got as a gift from Congress and the Supreme Court to eliminate your right to a jury trial. The way to combat this is to bring your action in court instead of making an arbitration demand and allege in your complaint that you were defrauded into agreeing to the arbitration provision itself because you should have been told about the high costs of arbitration, but were not. This should be pleaded as an implied representation, and that the corporation had superior knowledge and a duty to inform you that because of the high costs, the arbitration provision was in fact going to deprive you and others of any remedy, something which they knew. If the court agrees with you, you will be able to pursue your claims in court and get a jury trial. If the court disagrees with you, you will have to decide whether you can afford to litigate. Another strategy then is that if you keep your complaint in arbitration simple and eliminate various issues, you might be able to trim down your arbitration demand to something not requiring much time of the arbitrator and make the arbitration, quote, affordable, unquote, by giving up some of your arbitration rights. My name, once again, is Carl E. Pearson. Here is my website and telephone number. If you have any questions, I can handle litigation and arbitration matters anywhere in the United States, but when I practice law in the courts outside of New York State, I do so only with local counsel. Thank you very much.